The courtroom smelled faintly of varnish and old paperwork. Sunlight pushed in through tall, dust-smeared windows, landing in fractured lines across the glossy tile floor. It was only 9:15 a.m. on a Tuesday, but Fulton County's courtroom 4B felt more like a theater than a judicial chamber. Law students pressed shoulder to shoulder along the walls. Reporters filled the back benches, their recorders ready, their notepads angled. Even a few seasoned attorneys from nearby firms had wandered in, nudging each other with smirks, whispering jokes about a circus in the making. They weren't here for the docket. They were here for the kid. Judge Harlan Rodell sat hunched behind the bench, his shoulders stiff, jaw set. He wore thick-rimmed glasses that gave him the appearance of a tired librarian. He tapped a capped pen against his notes with a rhythm that said, "Let's get this over with." He had no patience for theatrics, but today he braced for them. Then came the sound of polished shoes on tile. Richard Langford entered with the kind of posture only decades of victory could shape. 60 years old, perfectly pressed gray suit, every strand of silver hair combed back like it answered to him. He didn't smile. He didn't nod at anyone. He simply walked controlled and deliberate to the plaintiff's table. No assistant trailed him. No junior attorney carried his briefcase. Richard Langford didn't need help. He was the help, the hammer that clients called when they didn't want compromise. They wanted a body count. He placed his leather case on the table, clicked it open with one hand, and pulled out a slim folder. That was all he needed. His presence alone did the rest. The man was a legend in Georgia. Legal circles had made his name defending city departments against liability suits and class actions. He didn't flinch under pressure. He applied it. And today across from him sat an 18-year-old with no degree, no lawyer, and no reason to win. Elijah Brooks walked in exactly 2 minutes later. The hush was immediate. He wore a navy blue blazer that sagged slightly at the shoulders, a wrinkled button-down shirt, and a tie that didn't sit straight. His shoes were polished, but the leather had gone dull with age. He carried no briefcase, only a manila folder clutched tightly under one arm. Some people in the gallery chuckled. One reporter scribbled something and shook her head. Langford didn't even look up. He assumed the trial wouldn't last through lunch. But Elijah didn't look around. He didn't pause at the door, didn't hesitate, didn't shrink. He walked straight to the defendant's table, set his folder down carefully, and sat, his back straight. Hands folded, eyes locked forward like he was already inside the case. Judge Rodell glanced over his glasses. "This is Brooks versus Cobb County Police Department, civil matter complaint filed under Title 42, Section 1983. Mr. Langford, you are here on behalf of the plaintiff." Langford stood with one smooth motion. "I am your honor. And Mr. Brooks, you've chosen to represent yourself." Elijah stood. "Yes, sir." No stammer. No wavering. There was a murmur across the room. Someone whispered, "He's serious." Another leaned over and muttered, "This'll be over fast." Judge Rodell blinked once, then scribbled a quick note in his ledger. Langford sat back and crossed one leg over the other. His expression was unreadable, but behind the stillness was a quiet smirk. To him, this was a message case, a symbolic lawsuit from a kid who'd felt slighted by law enforcement and wanted to make a point. Langford wasn't there to debate morality. He was there to remind the courtroom that emotion didn't win civil claims. Evidence did. And the kid, he wouldn't last 5 minutes. But Elijah didn't fidget. He didn't shuffle papers. He stood again when prompted and approached the podium without notes, without a screen, without backup. He spoke with the calm of someone who'd practiced every word alone. "What happened to me wasn't an accident," he said. And it wasn't just unfortunate. A few people straightened in their seats. It was avoidable. And the only reason it happened is because someone didn't see a person. They saw a problem. The room didn't erupt, but it shifted, and almost imperceptible tension changed the air. Langford looked up, brow furrowed now. "I'm not a lawyer," Elijah said, "but I am a citizen. I've read the law. I've studied the rulings. And I'm not here to perform. I'm here to prove what happened and why it should matter." Judge Rodell raised his chin. He wasn't smiling, but something behind his eyes said, "Go on." For the first time that morning, no one in the courtroom laughed. The moment the witness took the stand, the courtroom shifted. Officer Brent Caldwell moved with the confidence of someone used to being obeyed, not questioned. His posture was textbook law enforcement, back straight eyes, steady hands folded. The uniform was immaculate, the kind pressed with ritual precision, a shield made not only of fabric, but of routine. He nodded respectfully to the judge, then sat as if this testimony was just another box to check before lunch. Elijah watched carefully. Not for weakness, for patterns. He'd studied those too. The courtroom remained silent except for the soft shuffle of pages from legal pads and the occasional creak of wooden benches. The fluorescent lights above hummed faintly, but everything else seemed to be holding its breath. No one expected this case to last beyond a single afternoon, let alone unfold like a slow, deliberate dissection of authority. But that was what Elijah had planned, precisely that. He rose without ceremony, approached the lectern, and began not with accusation, but with a kind of gentle inevitability. Every question he posed was simple measured and left little space to evade. He asked the officer to recount what he remembered about that February afternoon. The call, the scene, the decision to stop a young man standing near a gas station. Officer Caldwell described it plainly, a suspicious individual loitering by the entrance. That was the phrase that kept repeating in his reports, and now in his tone, suspicious, like a reflex, like an assumption. Elijah pressed into that word without raising his voice. He asked about the physical space. There was no sign posted, no formal rule against standing where Elijah had stood. He had not spoken to anyone. He had not blocked an entrance. He had stood there briefly, then entered the store to make a purchase. Then stood again. That was all. There had been no confrontation, no yelling, no disobedience. Just standing, then questions, then cuffs. Without blinking, Elijah asked the judge to allow the jury to view the store's surveillance footage. The screen lit up and played a grainy video, time-stamped and steady. There was Elijah captured by a fixed camera, walking toward the door, entering, exiting with a bag in hand. He checked his phone alone. Then a patrol car pulled into frame, stopping sharply. The rest was inferred. No sound, no struggle. Just a quiet before things went wrong. Elijah let the video speak for itself. He didn't over-explain. He didn't dramatize. The silence in the room now felt different. It was no longer expectant. It was reflective. The footage confirmed what Elijah already knew, that the official story had been stretched to fit a conclusion it had never earned. Next came the audio. He introduced it not with flair, but with calm explanation. He had recorded it on instinct, an act of quiet defense of preservation. The recording was brief. It opened with Elijah asking in an even voice why he was being stopped. The officer barked a command, "Don't talk hands on the car." Then the clinking of handcuffs. And silence. It was a moment so ordinary it might have been dismissed, if not for how completely it contradicted the written reports and the accusation of non-compliance. The courtroom held that stillness again, the kind that meant people were recalibrating their assumptions in real time. Elijah turned slowly, letting the weight of it settle without commentary. This was not an isolated misunderstanding, he reminded them. It was the result of a pattern. a system not broken by accident, but calibrated by design. His presence, his skin, his clothes, the neighborhood, all of it had been enough to trigger suspicion. Not behavior, not action, just being. He described the arrest not with fire, but with precision. How his questions were interpreted as resistance. How confusion became cause. How silence was used to justify control. He explained what it felt like to be forced against a car hood while people watched. What it did to him, not in bruises, but in memory. The courtroom didn't stir. It listened. Across from him, Richard Langford sat unusually still. He hadn't yet objected, hadn't interrupted. Not because he had no argument, but because something in the room had changed, and he knew it. The usual rhythm of discredit and dismissal had stalled. The story he expected to swat down was turning into something far more dangerous than drama. It was becoming credible. Elijah didn't push the moment too far. He didn't raise his voice or demand sympathy. He returned to his seat as methodically as he'd risen. The screen went dark. The audio was turned off, but the questions now lingered in the room louder than any cross-examination could deliver. What makes someone suspicious? Who gets the benefit of the doubt? And what does it cost to be calm, correct, and still be considered a threat? When Elijah reached into his folder and pulled out the notebook, it looked unimpressive. Its black cardboard cover was bent at the corners, the spine held together by strips of old clear tape. Pages inside were lined with tiny handwriting, crammed edge to edge, some dog-eared others marked with color-coded sticky notes. It looked like a study guide from a community college midterm, not a courtroom exhibit. And yet, as he held it, the room leaned in again, not because of what it was, but because of how he held it. Like it meant something. He didn't introduce it dramatically. No proclamations, no lofty metaphors. Just the plain truth. This notebook, he said, has 122 pages. I filled them in the 6 weeks after I was detained. He opened to a page marked with a faded red tab and continued. Not with arguments, not with emotion, with facts, rulings, definitions, notes on procedure, mistakes I made and corrected. There was no pride in his tone, only discipline. He wasn't showing off, he was showing work. He spoke slowly, precisely describing nights at the Smyrna Public Library, copying passages from borrowed textbooks into the margins of that very notebook, using the free public Wi-Fi to watch recordings of real court hearings, parsing every phrase, every question, every objection. The audience didn't move. Not the students, not the reporters, not even Langford, who had stopped flipping through his own notes and now sat with his fingers steepled beneath his chin. Elijah told them how he found Terry v. Ohio first by accident, a footnote in a legal pamphlet about search and seizure. He didn't understand it at first, so he wrote it out word for word. Then he rewrote it in simpler terms. Then he compared it to his own experience line by line, decision by decision. He went further. He traced that ruling's influence to Illinois versus Wardlow, then Graham versus Connor. He charted how the courts had defined reasonable suspicion, and how those definitions evolved depending on race location and the lens through which an officer viewed a suspect. He mapped it like a blueprint of the legal machine that had once labeled him non-compliant. It wasn't just knowledge, it was survival. He explained how every Sunday, a retired paralegal named Mrs. Elva Romero met him at the community center near his job. She brought her old law dictionaries, her highlighters, her thick-rimmed glasses. She never charged him. She never patronized him. She only quizzed him, corrected him, pushed him to make his case better. When he got discouraged, she reminded him the law belongs to everyone, not just to those who can afford it. There was a moment of stillness when he said that, not because it was profound, because it was real. Then Elijah returned to the case itself. With that same notebook open in front of him, he walked through the timeline again. His shift at the warehouse, the stop at the gas station, the exact number of minutes from when he exited the store to when the police cruiser arrived. He showed his notes tracking the sequence against the body cam timestamps and the store camera footage. He pointed to a scribbled diagram of the parking lot labeled with distances and sight lines, how far the officer had to be to make the assumptions he made. He let the math speak louder than the emotion. No theatrics, just structure, just clarity. Langford sat unmoved, but no longer amused. Something in the room had shifted, something foundational. This wasn't a boy improvising. This wasn't a viral clip waiting to happen. It was a slow dismantling of everything the courtroom had assumed about what power looks like and who deserves to be taken seriously. Elijah spoke not with the polish of a trained attorney, but with something more dangerous understanding. The kind that wasn't taught, but earned. The kind that couldn't be easily dismissed. For years, Langford had built defenses by picking apart inconsistencies, exploiting hesitations, and turning passion into irrelevance. But Elijah had come with none of that. What he offered instead was harder to discredit order, precision, and quiet credibility. As Elijah closed the notebook and placed it back on the table, he didn't look proud. He looked tired but resolved. The gallery didn't clap. The jury didn't shift. But the silence he left behind wasn't the same as before. It no longer asked, "Can he really do this?" It asked, "What happens if he can?" The judge said nothing. Not yet. But he leaned forward slightly, just enough to show that he too was watching differently now. Elijah returned to his seat. He had more to say. But for now, the notebook had said enough. By the time Elijah rose to speak again, the room no longer carried the smug certainty it once had. The legal community knew posture. They could recognize a bluff, a rant, a moment stretched too long. But this wasn't one of them. Elijah hadn't raised his voice once. He hadn't tripped over a citation. He hadn't sought pity or applause. He had moved with deliberate quiet, like a man unpacking something fragile. Now, as he stood before the jury again, he didn't carry the notebook. He brought nothing but his voice. And somehow, that made the space feel heavier. He began not with a fact, but with a memory. It was Thursday afternoon, February 11th. His shift at the warehouse had ended late, 5 hours of stacking crates and sweeping aisles on tired legs. No lunch break, no music, just the slow churn of hours. He stopped at the gas station because it was routine. He needed something salty, something cold, something cheap to keep him upright for the bus ride home. He described it without embellishment, walking into the store, buying a bag of Doritos and a bottle of orange soda, stepping outside, pausing near the curb to check his phone. A group text from his cousin, something about the game that night. Nothing urgent. Then came the car. The patrol cruiser didn't ease into the lot. It pulled in fast, angled like a move rehearsed. The officer stepped out, called to him. He asked what was wrong. No answer. Just another command. Hands on the car. Elijah said he hesitated maybe 2 seconds. Not because he refused, but because it didn't make sense. Because he hadn't done anything. Because it took a moment to shift from everyday to alert. That's when the cuffs went on. He described them not with drama, but detail. Too tight. Plastic biting skin. No explanation. No charge. Just restraint and silence. He spoke slowly, letting the details land not like punches, but like echoes. Not for effect, but for memory. The part that stayed with him, he said, wasn't the officer's silence or the pressure of cold metal on his wrists. It was the girl. She had stepped out of a minivan at the next pump, maybe 7 or 8 years old. She held her mother's hand, chewing on the corner of her jacket sleeve. When she looked over and saw him, her hand tightened around her mother's fingers, and she stepped back, subtly but clearly. She didn't know him, but she had already learned what to think of someone who looked like him in handcuffs. That Elijah said was the moment that stayed. He didn't cry. He didn't raise his voice. But his words hung in the air like fog. They didn't need volume to sting. They had gravity. Even Langford, polished and unreadable, stopped moving. The jurors sat straighter, but not because they were tense. They were listening, and listening differently. Elijah didn't pivot to the law. Not yet. He wasn't trying to win at that moment. He was trying to show them what had been taken. Not property, not money, but a thread of something softer dignity. He described being released 20 minutes later with a casual apology and a dismissive wrong guy. No report corrected, no names taken, no badge numbers exchanged, just the vague kind of mistake that never really gets accounted for because it happens to the kind of person systems don't expect to speak back. He didn't call it injustice. He didn't use the word racism. He didn't need to. He simply asked the jury one question. What if I hadn't stayed calm? He let it breathe. What if I'd asked louder? What if I'd pulled away instead of pausing? What if my voice had cracked? My arms had flinched? My frustration had shown? Would we still be in a courtroom? Or would I be a headline? There was no answer. Not from the jury. Not from the gallery. Not from the judge. The room simply held that question in place, knowing it couldn't be dismissed with legal precedent or courtroom protocol. Then Elijah did what few expected. He said he wasn't asking for a payout. He wasn't filing this case because he wanted headlines or revenge. He brought it forward because the system had told him to move on, and he refused. He wanted one thing: someone to finally say, yes, this happened, and it shouldn't have. That was the line that stayed. The courtroom didn't stir. No coughing, no whispering. Even Langford's foot had stopped tapping. Judge Rodell sat motionless, pen paused over his ledger. Elijah nodded once and stepped back. No fanfare, no gaze toward the jury. He returned to his seat as quietly as he had stood. And in that silence, the system itself felt exposed, not by fury, but by truth spoken softly enough that no one could look away. The courtroom reconvened after a brief recess, but the mood hadn't reset. It carried the weight of everything Elijah had said. The gallery, once buzzing with skepticism and low-key laughter, now felt subdued, like a place where something important had already happened, and no one wanted to disturb its shape. Langford rose first for his closing. The man who once entered the room like a storm now moved with care. His voice was steady but different, measured not in strength, but in restraint. He reminded the jury that police officers are asked to make decisions in imperfect situations, that fear perception and pressure all affect judgment, that policy doesn't always fit cleanly into hindsight. But he didn't speak as long as expected. He didn't pivot to discredit. He didn't attack Elijah's preparation. Instead, for the first time in the trial, he acknowledged the reality beneath the procedure. Mr. Brooks believes he was targeted, and after listening to him, I believe he's right to feel that. I can't argue his experience. I can only ask you to weigh the law. He sat down slowly, like he wasn't sure whether he had just finished an argument or admitted a truth. Then came Elijah's turn. He didn't approach the podium. He simply stood. He said he'd been told this case would be a waste of time, that the system wouldn't take him seriously, that he'd embarrass himself. And maybe I was supposed to, he added. Maybe I was supposed to be overwhelmed by the rules and the silence and the weight of who usually wins. He looked at the jury now, not as challengers but as people. But I read the law anyway. I read it until I understood it. I followed the rules. I presented the facts. And all I'm asking you to do is see what happened not through fear or uniforms or habit, but clearly. Then he thanked them. No appeal to emotion. No final twist. Just clarity. The judge nodded and excused the jury for deliberation. The door clicked shut behind them, and for the first time in days, Elijah sat back. He didn't speak. He didn't glance at the reporters scribbling along the edge. He just sat, hands folded, gaze forward, as if still somewhere inside the case. 31 minutes later, the jury returned. The forewoman handed a folded slip to the bailiff. Judge Rodell unfolded it slowly, eyes scanning before his voice echoed through the chamber. In the matter of Brooks versus Cobb County Police Department, we find in favor of the plaintiff. A rush moved through the gallery, soft, reverent. No cheers, just quiet astonishment. Someone exhaled loudly. Someone else pressed a hand to their mouth. But Elijah didn't move. Not right away. He looked down at the table, then up, as if translating the moment into meaning would take longer than hearing it. Langford gave a small nod. It wasn't defeat. It was acknowledgement. The judge banged the gavel gently. Court adjourned. Reporters gathered like ripples around a stone. Microphones reached for statements. One asked Elijah, "How did you pull this off?" Another shouted, "Do you want to be a lawyer now?" He smiled faintly, but didn't answer. Not yet. He stepped outside into the cool Georgia air, the courthouse behind him, the weight of it slowly loosening from his shoulders. Later that day, in a back room at the warehouse, Elijah clocked in like always. No applause, no spotlight, just pallets, checklists, and the soft squeak of worn rubber soles on concrete. He didn't bring up the verdict. His co-workers didn't either. Some had seen the news, others hadn't. That was fine. At home, his younger brother scrolled through his phone during breakfast, grinning. "You're trending," he said. "The clip where you said, 'The law belongs to the people.'" It's everywhere. Elijah sipped his water and nodded. Good. Maybe someone else hears it. A knock on the front door interrupted. It was Mrs. Elva Romero, the retired paralegal. She held a manila folder under her arm. "Printed your transcripts," she said, "and a list of scholarship deadlines. Also, I may have called a few friends." He raised an eyebrow. She smiled like she'd planned it all along. "Georgia State's community law program is expecting your application." He took the folder and didn't say anything at first. She tilted her head. "Don't think too long. Doors open, but they don't stay open." That night, an email came from a nonprofit legal initiative based in Birmingham. Subject line, "Saw what you did. Let's talk." 2 days later, a law student who had watched from the gallery reached out to him on social media. Her message was short. "I've got my bar exam in July, and I'm just saying your cross was cleaner than most of mine." Elijah replied simply, "I wasn't afraid to lose." Weeks passed. The courthouse story faded from the news cycle. The verdict was archived. The clip disappeared beneath the churn of newer stories. But something stayed. Because what Elijah Brooks had done wasn't just about one case, one officer, one mistake. It was about where the line gets drawn, and what happens when someone who's not supposed to speak finally does. He didn't change the system that day, but he cracked it. And someone else would walk through that break. Because now they knew it was possible.